In the quiet glow of countless screens, a generation finds connection, laughter, and fleeting moments. Snapchat, with its playful filters and disappearing messages, became an emblem of this digital youth, a vibrant playground for millions. But beneath the surface of ephemeral fun, a darker narrative began to emerge, whispered at first, then shouted in courtrooms. The very design meant to engage, critics now argue, may have been engineered to ensnare, especially the most vulnerable among us. Snap Incorporated, the company behind Snapchat, burst onto the tech scene, captivating users with its unique approach to communication. Evan Spiegel, Bobby Murphy, and Reggie Brown created something revolutionary, tapping into a desire for authenticity and momentary sharing. Its growth was meteoric, transforming from a quirky app into a global phenomenon, boasting hundreds of millions of daily active users. For years, it seemed unstoppable, a testament to innovation and user engagement. Yet, as Snapchat's influence expanded, so did the murmurs of concern. Parents, educators, and mental health professionals began to voice anxieties about the app's impact on young minds. The relentless stream of content, the pressure of maintaining streaks, and the constant digital comparison, many argued, fostered environments ripe for anxiety, depression, and even addiction. What started as innovation was increasingly viewed by some as exploitation of developing brains. These whispers eventually coalesced into a thunderous roar in the legal arena. Families, shattered by tragedy or witnessing their children spiral into severe mental distress, began to seek accountability. They looked not just at the users or the content, but at the very architects of the digital experience. The first lawsuits emerged, tentative at first, then growing in number and ferocity, all pointing fingers at Snap Incorporated's design choices. At the heart of thousands of these lawsuits lies a powerful accusation that Snapchat's design is intentionally addictive. Plaintiffs contend that features like the Snap Streaks, continuous notifications, and an algorithm engineered for endless scrolling are not benign user engagement tools, but sophisticated mechanisms designed to maximize screen time. This, they argue, traps young users in a compulsive loop, leveraging psychological vulnerabilities for profit. Beyond addiction, a critical element of the legal challenge centers on youth safety. The lawsuits claim Snap Incorporated failed in its responsibility to adequately protect its youngest users from online predators, cyberbullying, and harmful content. While the Internet, by its nature, presents risks, plaintiffs argue that Snapchat's specific features, like quick audio and location sharing, created unique and exacerbated vulnerabilities for children and adolescents. To understand the gravity of these claims, we must delve into the legal framework being invoked. Many lawsuits are pursuing product liability claims, arguing that Snapchat itself is a defective product. This is a novel approach, typically applied to tangible goods like faulty cars or dangerous medicines. Here, the defect is alleged to be in the app's design and its foreseeable harm to developing minds, making it unreasonably dangerous for its intended users. Alongside product liability, many plaintiffs are also alleging negligence. This argument asserts that Snap Incorporated had a duty of care to its users, especially minors, and that it breached this duty by knowingly designing an addictive platform and failing to implement sufficient safety measures. The central question becomes, did Snap Incorporated know or should it have known about the potential harms, and did it act reasonably to prevent them? Establishing causation is one of the most formidable hurdles for plaintiffs. Connecting a specific app feature directly to a user's mental health decline or tragic outcome is incredibly complex. The defense often argues that myriad factors influence mental well-being, including family dynamics, pre-existing conditions, and other societal pressures. Proving that Snapchat was the direct and primary cause requires robust scientific and psychological evidence. What began as a trickle of individual cases has now swelled into a torrent. Attorneys across the United States have coordinated efforts, consolidating similar claims into multi-district litigation. This strategy streamlines the legal process, allowing common issues of fact and law to be addressed more efficiently. The sheer volume of these filings underscores the widespread concern and the shared experiences of families seeking justice against Snap Inc. Snap Incorporated, for its part, vehemently defends its platform and its commitment to user safety. The company highlights its continuous investment in safety features, parental controls, and resources for mental health support. They argue that Snapchat is designed to foster connection, creativity, and self-expression, providing valuable social experiences for its community. Their legal teams are prepared for a protracted battle, emphasizing user agency and the difficulty of attributing complex societal issues solely to a single platform. The courtroom battles are becoming a crucible for expert testimonies. Psychologists, neuroscientists, and digital design specialists are being called upon to shed light on the mechanisms of addiction and the developing adolescent brain. Plaintiffs bring experts to demonstrate how specific app features exploit vulnerabilities, while the defense counters with experts who emphasize the benefits of social connection and the complexity of individual user experiences. These testimonies are crucial in shaping judicial and public understanding. A critical aspect of discovery in these cases involves the unearthing of internal company documents. Plaintiffs seek evidence of internal research, design discussions, and executive communications that might reveal an awareness of potential harms, or even intentional design choices aimed at maximizing engagement at the expense of well-being. The hope is that these documents could expose a gap between public statements and internal corporate understanding, proving intent or negligence. Beyond the civil lawsuits, a parallel track of legislative action is gaining momentum. Lawmakers, spurred by public concern and legal pressure, are exploring new regulations targeting social media companies. Some proposals, like versions of a Youth Protection Act, aim to mandate stricter age verification, impose design limits to curb addictive features, and enhance parental control options. This legislative push could fundamentally reshape how platforms like Snapchat are allowed to operate. It's not just the United States where Snap Incorporated faces legal and regulatory pressure. Countries across Europe, as well as Australia and Canada, are also intensifying their scrutiny of social media platforms and their impact on youth. Privacy regulations like GDPR have already set precedents for digital accountability, and new frameworks are being considered to address addiction and mental health specifically. This global chorus amplifies the pressure on tech companies. Behind every legal brief and expert testimony lies a deeply personal story of struggle and loss. Families describe children once vibrant and engaged, transformed by relentless social media use into isolated, anxious, or depressed individuals. Some accounts detail tragic outcomes, claiming direct links between app usage and severe mental health crises. These heartbreaking narratives are the emotional core driving the thousands of lawsuits forward, giving a human face to complex legal arguments. A significant focus of the lawsuits is on the power of algorithms. Plaintiffs argue that Snapchat's algorithms, like those on many social media platforms, are designed to learn user preferences and then feed them an endless stream of increasingly engaging, and potentially harmful, content. This personalized feedback loop, they contend, is particularly dangerous for impressionable young users, deepening their engagement while potentially exposing them to content that fosters self-comparison or unhealthy obsessions. One key area of contention in court is whether Snap Incorporated was aware of these potential harms early on and chose to prioritize growth and engagement over user well-being. Plaintiffs' attorneys are combing through academic research, internal memos, and even former employee testimonies that might suggest the company received warnings about the addictive nature of its features or the vulnerabilities it created for young people, yet failed to act decisively. Snap Incorporated consistently points to the parental controls and safety tools it has implemented, arguing that it provides resources for families to manage their children's app usage. However, plaintiffs often counter that these controls are either insufficient, difficult to navigate, or simply ineffective against the powerful psychological engineering of the app itself. The debate centers on whether the onus is solely on parents, or if platforms bear a primary responsibility for designing safer digital environments. A critical legal defense for social media companies, including Snap Incorporated, is often Section 230 of the Communications Decency Act. This provision generally protects platforms from liability for content posted by their users. However, plaintiffs in these addiction and design cases are attempting to sidestep Section 230, arguing that their claims are not about user-generated content, but about the platform's own product design choices. This legal maneuver could set a monumental precedent. The outcomes of these thousands of lawsuits against Snap Incorporated hold immense precedent-setting potential. If plaintiffs succeed in proving addictive design as a defect or negligence, it could redefine product liability for the entire tech industry. It might force a fundamental shift in how social media apps are designed, moving away from engagement at all costs models towards designs prioritized for user well-being and safety, especially for minors. While many cases are still in their early stages, there have been reports of initial settlements in some individual claims. These confidential agreements, while not an admission of guilt, often signal a desire by companies to avoid prolonged, public trials and potentially larger jury awards. Each settlement, however small, adds to the cumulative pressure on Snap Incorporated and other platforms, demonstrating a willingness to acknowledge some level of responsibility, even if not legally declared. A core demand from advocates and plaintiffs is greater transparency from social media companies. They seek access to data on user engagement, internal research on mental health impacts, and detailed breakdowns of how algorithms operate. This push for transparency aims to empower external researchers, policymakers, and parents with the information needed to assess risks independently, rather than relying solely on company-provided data. The legal process is, in part, a battle for this access. These legal battles signal the dawn of a new era of digital accountability. For years, tech companies operated largely unchecked, lauded for innovation and growth. Now, the focus is shifting towards the societal costs and ethical responsibilities inherent in their massive influence. The lawsuits against Snap Incorporated are not isolated incidents but part of a broader movement to hold powerful digital entities accountable for the real-world impact of their products. In various courtrooms, and through powerful media interviews, former Snap Incorporated employees have occasionally come forward, offering their perspectives. While their statements are often carefully vetted and subject to legal scrutiny, some have corroborated concerns about internal pressures to maximize engagement, even when potential negative impacts on user well-being were discussed. These insider testimonies, when admissible, can significantly bolster plaintiffs' claims of corporate awareness. Beyond addiction and general safety, some lawsuits against Snap Incorporated also include allegations related to revenge porn and the platform's role in facilitating the non-consensual sharing of intimate images. While this issue is broader than Snapchat alone, specific features and the perceived impermanence of content have sometimes been cited as factors in such cases. Plaintiffs argue the company should have had more robust safeguards against such severe violations of privacy and consent. The current legal landscape highlights a pressing need for clear industry-wide standards for social media design and youth protection. Advocates argue that individual lawsuits, while important, are not enough. They call for collaborative efforts between tech companies, governments, and child development experts to establish universal guidelines that prioritize safety and well-being from the outset, rather than reactively addressing harms after they occur. This could fundamentally shift the design paradigm. Any legislative or judicial action against social media companies inevitably encounters First Amendment concerns, particularly regarding free speech. Critics of regulation argue that restricting app design or content curation could infringe on the constitutional rights of platforms and users. The legal system must carefully balance these protections with the imperative to protect vulnerable populations, especially minors, from harm. This balance is a central tension in the entire legal saga. The thousands of lawsuits against Snap Incorporated represent a legal journey that will likely span years, if not a decade. Discovery, expert testimonies, appeals, and potential class action certifications mean a protracted and arduous battle for all parties involved. This isn't a swift resolution but a marathon, with each legal victory or setback shaping the path forward for digital responsibility. The stakes are incredibly high, not just for Snap Incorporated, but for the entire tech ecosystem. One possible outcome for Snap Incorporated is a series of large-scale settlements. Faced with mounting legal costs and the risk of adverse jury verdicts, the company might opt to resolve many cases out of court. While settlements avoid formal admissions of liability, they would still carry significant financial implications and could require the implementation of new safety features or design changes as part of the agreement, impacting future product development. Another, perhaps more impactful, outcome is the establishment of a binding judicial precedent. If a court rules that addictive design constitutes a product defect or that social media companies owe a specific duty of care to minors, it would send shockwaves through the industry. Such a ruling could compel all platforms to fundamentally redesign their products, prioritize user well-being over engagement metrics, and implement robust age-appropriate safety measures. Beyond courtrooms, the outcome could also be a heightened regulatory environment. Lawmakers, emboldened by judicial findings or continued public outcry, may pass comprehensive legislation. This could include mandates for independent safety audits, restrictions on algorithmic practices, or even a ban on certain features deemed harmful to minors. Such regulations would move beyond voluntary industry guidelines, imposing strict legal requirements with significant penalties for non-compliance. Regardless of the specific legal outcomes, this period marks a pivotal moment for the technology industry. The unchecked pursuit of engagement metrics is now being challenged by a powerful counter-narrative of responsibility and well-being. Companies like Snap Incorporated find themselves at the forefront of a redefinition of their ethical obligations, facing the prospect of having their foundational business models scrutinized and potentially reshaped by external forces. The thousands of lawsuits also represent a profound shift in user power. For too long, users, particularly young ones, have been viewed largely as passive consumers or data points. These legal challenges assert their rights as vulnerable individuals deserving of protection, pushing back against the narrative that responsibility for digital well-being lies solely with the individual. This collective action empowers a generation to demand safer, more ethical digital environments. While Snapchat is currently at the epicenter of this legal storm, its outcome will reverberate across the entire social media landscape. Other platforms face similar allegations and are watching these cases closely. The ultimate decisions made in these courtrooms and legislative bodies will undoubtedly influence the future design, regulation, and ethical responsibilities of all companies that create and operate digital environments for global audiences, especially for the young. We stand at a digital crossroads. On one path lies continued innovation guided by engagement metrics, with legal and ethical consequences navigated reactively. On the other, a future where technology is consciously designed with human well-being at its core, particularly for the next generation. The thousands of lawsuits against Snap Incorporated are not just about a single company or app, they are a profound societal dialogue about the kind of digital world we want to build for our children. The answer remains to be written.